Welcome to the 2011 series, our Student Scholar Series. This was started in 2009, and it's just amazing that we're now in our third year of doing this. It is a wonderful program that Professor Harmon started, which allows us to recognize extraordinary scholarship on the part of our students. Our students are always writing many important papers, and some of them are getting them published in our journals that we have here at the school, but we know so much more is done on a day-to-day basis in these courses. And this creation, this idea of Professor Harmon's has allowed us to create another venue, another opportunity to celebrate excellence in scholarship on the part of our students. And I am so delighted today to be able to welcome Mr. Ted Bush, who will be graduating in May, to present his paper entitled Combating China's Undervalued Currency, a Subsidy in Fact and in Law. And my colleague Heidi Schooner will be the person who will comment on his paper and take him through the ropes in terms of his defense of his thesis. But I'd like to ask Professor A.G. Harmon to come forward so that we can recognize him for this terrific program that he's started. Thank you.
Thank you, Dean Miles. I would like to, before I introduce Ted, let me just say a few words about Professor Schooner, of course, who has joined our faculty here, I think in 1993. She was the acting general counsel before that of the First American Metro Corporation, and also practiced in the general counsel's office of the Securities and Exchange Commission. She's authored numerous articles addressing both the domestic and international challenges in regulating the banking and securities industries, and has co-authored a textbook on international bank regulation entitled Global Bank Regulation Principles and Policies with Michael W. Taylor. Professor Schooner's scholarship examines financial services regulations, and we thank her especially for taking part in the discussion today. As the Dean mentioned, the first of our student scholars this year is Ted Bush, who is a third-year student. His work was nominated by Professors Steve Margeton and Pat Pettit, who I'd like to thank for coming today. They did a fine job for bringing the Ted to the committee's notice. Ted graduated from Marquette University in 1999 with a BS in Business Administration, Finance, and Political Science. While an undergraduate, he interned for Senator Russ Feingold and spent a summer at the Clinton White House. He worked for Representative William Lipinski as a legislative aide from 1999 to 2004, and then spent 3 years lobbying for industrial associations on Capitol Hill. During this period, he focused on international competitiveness issues for small manufacturing companies, and in doing so, he interacted directly with dozens of House members and several U.S. senators. He lobbied for IT companies on cybersecurity issues in 2008 and 2009. His research, which he'll speak to you about now, sprang from an interaction that occurred while he was working as a legislative aide. An industrialist in Chicago approached Congressman Lipinski on the trade consequences of China's undervalued exchange rate. For several years, he was the most active staffer and lobbyist on this issue. And his own father has been counsel at a manufacturing company in Wisconsin for 30 years, so the loss of the industrial base is an effect of which he is keenly aware. I'll turn the floor over now to the first of our 2010-2011 student scholars, Ted Bush. The topic of his presentation, again, Combating China's Undervalued Currency, a Subsidy in Fact and Law. Thank you, Ted.
Thank you. Hello, my name is Ted Bush. I'm 3L, and if published, my note will be the first research note that argues affirmatively that there is an existing trade law remedy for China's undervalued currency. I would like to make a few acknowledgments because I see some people in the audience. Obviously, Professor Harmon, who's helped me a lot, and Professor Schooner getting ready for this presentation. But I also noticed that Professor Destro, Professor Ogilvie, and of course Professors Margeton and Pettit are in the audience, and they taught me a lot, and I appreciate their attending. Hopefully I can return the favor in making this informative, but I also hope to make it entertaining. I think I can do it. So I'm going to start a little bit framing the issue, and before I start, I also want to thank my wife. My wife has not been to the school before. She had a problem getting onto New York Avenue, or getting from New York Avenue to North Capitol on the way here, so she's almost here, and I wanted to acknowledge her, even in her absence. I wanted to frame the issue, and I purposely kept this out of the paper because it's sort of collateral noise. It causes people's own views to get involved. Things such as tariff policy and such. It's divisive, but nevertheless, just to introduce you to this subject, it's important to talk about. And there's a congresswoman from Ohio who you may be familiar with. Her name is Marcy Kaptur. She represents Toledo, an industrial district, and obviously her district has suffered a lot of loss in employment and industry. And this is one of the more important issues to her trade. And she frames basically all issues, important issues, as distinguishing members who are willing to constrain the global movement of capital, and that's really the litmus test for her. And I think that really represents a split in the Democratic Party today, is those that are willing to constrain international capital, or those that believe that international capital is most should be self-deciding, that it will find its own most productive uses absent government controls. There's also, I think, a debate in the Republican Party on this, but while the party is more free trade oriented and free market oriented, there's also a stronger national sovereignty element that runs through. So that's really where people come down on this. I think personally, one of the advice from Professors Margeton and Pettit was write something that you're most passionate about, and so I agree with Representative Kaptur that is the most decisive issue in public policy, and I think it will define politics for the foreseeable future. So, while this is sort of in my past, it is what I find most passionate, and that's why I decided to write about it. So just to go into why this subject matters on a macro basis, China continues to have the largest bilateral deficit with the United States by far. It's not even close. As you can see, $273 billion makes up over half of our total trade deficit. The other is mostly oil. So the manufacturing trade deficit is with China is by far the largest. There's balance of payments concerns as a result of this. It's been prolonged. It's been basically, we're going on 20 years of prolonged capital account deficits, or current account deficits, excuse me. And in 2003, Warren Buffett issued an article in Fortune magazine which characterized, the impacts of the current account deficit. And he characterized two different countries, one Squanderville and one Thriftville. And the implications to Squanderville over a long period of time is that eventually they would lose control of their assets, and they would effectively be working on their own rented land. So that's why he characterized it as Squanderville. He almost characterized a country with persistent current account deficits as a country that's a sharecropper country, and that's been influential. There's also the obvious loss of the industrial base and loss of manufacturing employment. In 2000, there were over 17 million industrial workers, and today, as of December, there are now 11,600,000. So that's a loss of a third of our industrial base, and those are skilled workers. And then, of course, there's geostrategic and national security concerns. As Professor Harmon noted in the introduction, I became involved in this issue in 2003 when an industrialist came, and there was anecdotal evidence throughout the Chicago region. I was working for a Chicago congressman, that there were manufacturers who were competing against finished goods that were less than the cost of their raw materials. And these are, the input costs are all world market prices. So there's obviously something going wrong. And they were dramatically downsizing their workforces, and some of them were shutting altogether. So just to go into China's currency. And they all looked at China. All the displacement was coming from what was known as the China price. China's currency is called the renminbi. The literal translation is the people's currency. The yuan is a unit of measurement. So if say someone's going to quote you the current rate, today's rate would be 6.59 yuan per dollar, or 1 yuan is 15 cents. I put up these two graphs. This first graph, right on the bottom left here, this starts in 2002. And the reason why I put up this graph is the rate was pegged to 1994. So what you would really see going back further is a straight line. And then you see that it starts to dip in 2005. And the reason why I put this up is it can be a little bit misleading. If you look at the left graph, which is the most commonly quoted rate of, let's say, 6.6 yuan per dollar, it'll look like the yuan has fallen, but in fact it's risen. So this is the rate. People don't, say 15 cents per yuan because it's just such a low number. So when I talk about the yuan appreciating, let's say if it appreciates 40%, the yuan will go from 6.59 yuan to 4.7 yuan. So the number will get lower, but the rate is getting higher as you get closer to dollar parity. So next, and I put up on this slide historical background, and I put I thought some notable numbers on the rates. In 1981, China had two currencies. They had an official rate, which was at this, by historical standards, a very high rate. And if you notice, they had something called the internal settlement rate, which was 2.8, which is almost twice the rate of the domestic rate. And that just shows you that if you were an exporter at that time, you were getting a substantial better deal in terms of trade, and you could, turn that into, a competitive advantage. There was international outcry, and they changed it. But then in 1993, they brought it back again. And at that time, it was called a swap rate, which was the exporter rate. And you can see that there was a differential of about 3 RMB per dollar even back then. In 1994, they unified the rate, so both the official and the external rate were both 8.7 yuan. That gradually appreciated a little bit. So they changed from well, what they did is they changed to a peg. And the peg went for about 8 years to 2005. And then they had two periods, one of which we're currently in, of a managed float, which is basically them controlling the value of the currency, but it gradually increasing. That happened amidst a period of international concern that that this was unfair. This happened for a few years during the Bush administration. Then they repegged it for 3 years, and now, as of last June, there is now a managed float again. And this next slide discusses the mechanics of how China actually operates its exchange rate policy. The traditional method is open market intervention. That when you think of currency manipulation, you think of a country going into the open market and buying a foreign currency with their own currency, increasing the value of the foreign currency, and lowering the value of their own currency by increasing their own currency and taking foreign currency out of circulation. So it's really a supply and demand device, which is the traditional way, and China does some of that. But what makes China's method so different is step one. And step one is very simply China just establishing a single rate. Every morning when you wake up, the Chinese government will provide to its exchanges the daily value down to the 10,000ths of a decimal. So it's very specific, it's very controlled. And they claim they do that against a basket of foreign currencies, but there's been a study that shows that the alleged basket that they're allegedly measuring their currency against instead of the dollar, which it was before, is basically dollars. It is directly controlled by the Chinese government. Then step two of how they do it is really to control a problem of black market valuation of the currency. Because they can set a rate, but the market can say, we don't believe you, this is not an accurate valuation, we're going to trade on our own rates. And so what they've done there is, I would consider a more traditional method to justify their price. And in 2003, you can notice that their foreign exchange reserves were $403 billion. And then 7 years later, their exchange reserves grew to $2.4 trillion. So in that period of time, the inference is that China printed $2 trillion of currency to take foreign currency out of circulation and lower the value of their own currency. That's just a stratospheric number. There's no country that's even close. And then the third way is that makes China unique is their capital controls, and they're called safe rules. These were created in 1996, and what I think is so striking about these rules is how explicit they are. And in fact, I'm going to quote from Article 7 of their safe rules. This is basically administrative regulations issued by the Chinese government. It says, quote, "Foreign currency is prohibited for circulation and shall not be quoted for pricing or settlement in the territory of the People's Republic of China." So that gives you an idea of how much they control the value of their currency. And it goes back to supply and demand. They require that all trade proceeds of Chinese exporters be brought back to China. And not only must they be brought back to China, they must be then delivered to the Chinese authorities via their banking authorities. The holding of dollars is prohibited, so what they do is it gives them a supply of dollars. They don't have to actually go out and get the dollars. The dollars come to them, they print the money, and the competitive advantage is conferred by that method. And then step 4, China has an inflation problem. I'm sure you've read about it. And because they're printing so many dollars, the logical question is, well, they must have a huge inflation problem. Yes, they do. They do that they mitigate that 3 ways. Number 1, by issuing domestic bonds, which takes currency out of circulation. They just, I guess you could say they flood the market with bond obligations. And then there's also forced reserves for Chinese banks, which means that they force Chinese banks to hold on to dollars instead of the government. So the dollars are still taken out of circulation, they're just held by someone else. The other way that they try to mitigate inflation is through window guidance, which is basically the Chinese government telling their lenders to slow down. Okay? Now going into the law. This issue is, I would say, somewhat unique in that it straddles monetary and trade policy. And I think this quote by Harry Dexter White, who helped found the International Monetary Fund, sort of gives the rationale of the rules that are enacted in the global trading rules and the International Monetary Fund. And the basic premise, as they were creating, during the Bretton Woods agreements with the IMF and the General Agreement of Tariffs and Trades, is you cannot use trade to take back your exchange rate concessions, and you can't use exchange rates to take back your trade concessions. So there's a dual role here, and that principle, by Harry Dexter White, is embodied in GATT Article 15, which is a title on exchange arrangements. And I think the thing most notable about Article 15 is that it's never really been used. The IMF has only engaged in, they call it special consultations twice, once in 1982 and once in 1987, 82 with Sweden and 87 with South Korea. And notably with Sweden, they had a change in government and they basically admitted to it. They came forward, they said, okay, yeah, you got us, we'll stop. But other than that, this entire body of law is de novo. It's untested, and there's even a debate about whether there's a cause of action under Article 15 of the GATT. most people think that complying with the IMF rules is an affirmative defense, but there's even a debate of whether a government can bring a complaint, whether a government is endowed with a cause of action to bring a complaint against another country. So that's part of the problem, I think. And, like I said, the issue straddles between finance and trade policy. And because the international framework for international banking is so weak, that's part of the reason why others have sought relief under the trade laws. So now I'm going to go into the trade laws. The Subsidies and Countervailing Measures Agreement is an annex to the underlying WTO GATT agreements, which were, this was created in 1994, and this is the first time the subsidy rules have applied to all WTO members. And basically a subsidy is what you might, intuitively conceive is it's just a benefit, a subsidy granted by a government. There have been some distinguished economists like Ben Bernanke and Martin Wolf of the Financial Times that have called it a subsidy, but that's not enough. There's a legal definition, and the legal definition is set forth in the SCM, which Article 1.1 defines a subsidy as a financial contribution by the government and a benefit conferred. In order for a subsidy to be actionable, meaning whether you could get countervailing duties, which is the offsetting tariff, depends on a specificity test. And on the issue of China's currency, as I'll discuss later, specificity is really the most debated element, and most of the scholars on this topic have concluded that it's not specific, and I'll discuss a little bit why I think they're wrong. But you can see that this is the law, and the subsidies that are contingent upon export are specifically defined under the Subsidies Code as being actionable, therefore legal. So now going into the thesis of the note, what it required to do is to go through all the three prongs of the test and identify why each of those prongs were met in this case. And I'm just going to read a little bit from the paper because this sort of lists the legal facts, and they're remarkably not complicated. It says, quote, this is the argument, simply, China fixes its desired dollar-RMB exchange rate through its central bank. It limits where dollar-RMB transactions can take place to China's foreign exchange entities that it controls. Then it executes the transaction at an administered price. Through state policy, China mandates all dollars in circulation be remitted back to its central bank, thereby reducing the supply of dollars and increasing the supply of RMB. This practice constitutes a financial contribution and a benefit, thus constituting a subsidy. It is prohibited subsidy because the subsidy is contingent on export. So that's really the thesis of the entire note, and there are a lot of consequences to that. I'm not going to go through and read, but there are about 90 WTO appellate cases that have been decided, and there are 4 that have discussed, what exactly the financial contribution requirement means. Just by scanning those, you can see that there's expansive language in the cases that indicate that what is a financial contribution is not strict, that a number of different things could come under its purview. And then the second element is the benefit. This is the least disputed amongst advocates. Most people believe that, assuming you can estimate the true market rate, which is an important assumption, you can the benefit is just a mere subtraction of the current rate minus the rate it should be, and that creates the benefit subsidy. And there's a couple other just references to cases that have discussed that criterion. And then the third element is specificity. Again, just citing a few cases, and I just wanted to, this is sort of an opportunity to talk about where some people have objected to this prong. most, I think, surprising is people argue that there's an intent requirement as subsidies code, and the simple answer to that is there's not. And the other objection to the specificity prong is that it's possible to bring dollars back to China via other ways other than trade. And principally, you could do that just by repatriating dollars. Let's say you get a gift of dollars and you bring those dollars back to China. That would be an exception. Or you could argue that foreign direct investment. Let's say you're a Chinese company, you build a plant in Pennsylvania. You wouldn't be exporting, you would be engaging in foreign direct investment. Therefore, the benefit is not contingent on export. And there are two cases, both involving the United States, where the WTO appellate body has rejected that argument. So there's, I think, ample case law on that subject. They've also argued things like there's a strict causation requirement and other things, which are really loopholes. And I thought the argument, and I know Professor Schooner's written on this subject, that there are systemic risk implications to a massive subsidy program, and to think that the WTO and the World Trade System would permit a few subsidies, or would ban a few subsidies, but allow a million subsidies is just not persuasive. So the consequence of the thesis, there are a lot of things that can be done. The most principal consequence of this legal finding is that the Department of Commerce has existing authority to levy countervailing duties against anyone who brings a complaint against China. That would be domestic industry, assuming that they can meet the requirements of causation and injury. And then, of course, the Department of Commerce has actually decided not to investigate this on the specificity prong. And the Court of International Trade in New York, which oversees the Department of Commerce, has the authority to review their initiation decisions and to overrule them. And, the other part of my paper argues that they should. And then lastly, that the U.S. Congress can pass legislation making it clear to the administrative regulators that currency undervaluation is within the scope of the Subsidies and Countervailing Measures Agreement. And there is, as I noted in the bottom, there's precedent, both in the United States government. It's historically applied to dual exchange rates. In Article 6 of the WTO, there's a specific prohibition on dual exchange rates, and so in the past, the United States has applied countervailing duties against countries that undervalue their exchange rate in regards to Germany and Uruguay. So there is precedent. It was just done by the Treasury Department several years ago. And so, moving on, I wanted to talk a little bit about the history of the legislative efforts. And an expert just walked into the room, Professor Malloy, who was with, highly involved in a lot of these. And I'll talk about this just a little bit later. I know we're running a little out of time here. The first legislation introduced on this subject was by Senators Schumer and Graham. And if you've read any stories about this, I'm sure you've read, senators to introduce their China currency bill, which would levy tariffs of 27.5%. What they did in 2003 is they took there was an estimate of 15 to 40% undervaluation in China, so what they did is they split the difference. And that was the bill that got all the headlines, and I'll explain a little bit, their unique legislative strategy, if you will, on their own bill. That, by the way, is totally WTO illegal. Everyone knew it. They knew it. Nevertheless, they, pushed it for about 5 years. 2004, there was a 301 complaint, which was based upon Article 15. And then in 2005, Ryan Hunter was legislation that would do, what this thesis encourages the Congress to do. They don't have to, but in order to eliminate any bureaucratic hesitancy at Commerce, it would basically effectively tell the authorities that they do have the authority to initiate an investigation. The Senate bill was introduced in 2006, and in 2007, the Senate Finance and Banking Committees did actually undertake a markup of this legislation, but they didn't do, they did something completely different, and it was sort of a jurisdictional squabble. And in 2008, Senator Obama, as a candidate, co-sponsored this legislation, and 2009 is when the aluminum extrusion industry and the coated paper industry filed complaints under this, theory. And in 2010, they were rejected. And finally, in 2010, the House passed the Ryan Murphy bill, which was, basically the original bill that was introduced in 2005 with some changes. So, I'm going to wrap up quickly. As a former lobbyist, I got to watch all of this, and I thought to myself at the time, I could really do a great presentation on how a bill does not become a law. And so as when I found out about this award and I started to prepare for this, I said, you know what? I think I can do it. And so we're going to start. This is my brief presentation on how a bill does not become a law. And this is step one. And it says Senate sponsors introduce a beard bill. And I'll get back to what a beard bill is. But this is a picture of Senators Graham and Schumer meeting with Alan Greenspan and John Snow, the former Treasury Secretary, I would say probably back in 2005 or 2006. And for a period of time, they actually in 2005, I called Senator Schumer's office, and I know that Senator Schumer is historically very amicable to cameras and being on television. And I called his office. I said, hey, we're going to introduce this bill. We think it's WTO consistent. We think it can pass. We'd like you to introduce the Senate version. And so I remember I was at a law office the next day, and I heard, Senator Schumer brought the bill to the floor of the Senate. So I'm like, oh my gosh, not only did he introduce our bill, he just attached it to a pending budget bill. And it turns out it was not our bill; it was his bill. And he saw us getting in the press and introducing a rival bill, so he got out in front of it. And over a period of time, there's sort of like a Lucy football, thing going on, where he would always, he's going to bring the bill to the floor, he's going to try to get a vote, and then he just backs off. And so this is Senator Schumer and Graham, doing one of their, conciliation. Well, we didn't introduce the bill, but we're going to have a discussion with Senators with Greenspan and the Treasury Secretary to discuss how concerned they are about the subject. And then over time, and I'll talk a little bit about this, we really discovered that they really weren't serious on legislating on this subject. And I called there's a reporter, a columnist at the Buffalo News. New York has a sort of dichotomy of the northern part of the state's doing terrible, the southern part, Wall Street's doing terrific. And I was explaining all this to this guy at the Buffalo News named Doug Turner. And he goes, oh, I know what that is. I'm telling him what Senator Schumer's doing. He goes, oh, I know what that is. He goes, that's a beard bill. And I'm like, well, what's a beard bill? He says a beard bill is something that politicians do. They introduce legislation to cover up something they don't want their constituents to see. So for senators to introduce a bill they don't support, that's a beard bill, and that's step one on how a bill does not become a law. The second, and Professor Malloy was involved in this, the second step a bill does not become a law is there's a jurisdictional fight between two committee chairmen. When we were going to introduce this legislation in the House the second time, I found out that Chairman Barney Frank, really wanted a role for his banking committee to be involved. And so we wrote a banking title into our House bill when we reintroduced it. And then ultimately, this bill, we reintroduced it into the Senate. And the Senate Banking and Finance Committee chairs got into an enormous fight. We couldn't get them to pay any attention to us. But finally, when they saw the other person's authority being treaded on, they got really involved, and they ultimately marked up legislation, but it wasn't what we wanted. So that's step two, is you may have a jurisdictional fight, but it's not going to, it may be entertaining, but it's not going to help you. The third step on how a bill does not become a law is the House of Representatives passes a scratch bill. And in this case, Doug Turner, this was another one of his terms, he defined what a scratch bill is. And this was similar to the Schumer legislation, but a House bill that was subsequently merged into another House bill that did nothing. It was sort of a precursor to pass CAFTA, the Central American Free Trade Agreement. A lot of members wanted to act on that before they passed CAFTA. And then the fifth step is, as I mentioned, Senator Obama co-sponsored this legislation as a presidential candidate in 2008, and I put the seals of the states of Indiana and North Carolina on there for a reason, because the Indiana and North Carolina primaries were unexpectedly contested. And what happened was the AFL-CIO got Senator Hillary Clinton to sign onto the bill. And what happened was Senator Obama had a member of his staff looking for every unanimous consent request filed to the Senate clerk that has any bill that Senator Clinton was going to co-sponsor. And it turns out that the aides saw that Senator Clinton was co-sponsoring the Bunning-Stabenow bill. And so the staffer put Senator Obama on the bill, so Senator Clinton couldn't tell the Indiana and North Carolina voters that she signed on first. So, later the Commerce Department under Obama denied, the petition, which, under agency law, he's a constitutional lawyer, he signed on the legislation, you could, potentially, go by his dictates, but they decided not to do that. So that's number 4. And then fifth, and the final, to conclude the presentation, is how a bill does not become a law as you think in the long term. And I included up on the slide, John Dingell, who I had some involvement with. He was sworn into the House in 1955. He's in his 56th year in Congress. At the end of 2006, when we knew our bill wasn't going to be passed, we had 180 co-sponsors, and we went to John Dingell and we asked for him, can you please, try once more to get this through? And his response back, and it was, you guys did a really good job. I mean, you brought this, issue forward, but it took me 10 years to pass the Clean Air Act, and so you should feel very, comfortable that you've gone this far. And so step 5 in how a bill does not become a law is to think in the long term. But the good news is that it's now been 8 years, and under Chairman Dingell's methodology, this bill will be passed hopefully within the next 2. So that's my presentation.
Sooner to have a response, just sit right there, and then we'll open the floor to any questions.
Thank you, Ted, so much. So listening to Ted's talk just reminds me how much I love being a lawyer. And so let me just tell you why really quickly, and then I'll have some comments on the paper. So many of you know I have a teenage son. And so many of our discussions at home and at his school are about teenage drinking. And you're wondering why this is relevant. It is. So we have questions like, so would you as a parent have teenagers at a party at your house and serve them alcohol if you took all their keys away? And of course my response is, no, it's illegal. So every question goes like that. It's easy for me, it's illegal. And that's sort of Ted's paper is, we're all whining about China and China this, China that. And Ted says, it's illegal, and it's. I mean, in all seriousness, it really is sort of what I love about lawyers and the law is how there's very difficult social policy issues that often the law seeks to address through legal rules and legal analysis, and we don't always get our way, we don't always get our bills passed, but we really do try to solve problems. So, I am not an expert on trade at all. In fact, everything I know about trade I read in Ted's paper a week ago. And there are many people in the audience that are experts on trade, so I will leave those very insightful questions to them. I will just talk a little bit about the noise because, Ted started out by saying the paper's not about the noise, and it really isn't. It really is a very cogent legal analysis, very persuasive, and it doesn't get sucked into some of the noise. But when you're talking about China, it's hard to not throw out some facts. So I'll give you the ones that I like in addition to the ones that Ted gave us at the beginning of his talk. So half of China's GDP is invested in currency reserves. If you're just thinking about the amounts of money, of foreign currency that they're holding, it's huge amounts. China is the world's largest exporter. That's probably obvious, but I just try to emphasize the fact that to the extent that they are subsidizing their exports, that has a very significant impact on global trade. One thing that Ted talked about when he presented this paper to my class on international bank regulation, and one thing that he did a great job of exploring with the other students in the class was the disparate impact that China's policies has on businesses. So this is not a problem for global corporations that just go to China and sell from there, right? It really is a problem of more domestic industry, more domestic, smaller companies. And so I think that's sort of important to keep in mind in terms of the background. So I just have two sort of questions, and Ted, you can answer them, but then I really would like to open it up to the floor. And again, they sort of are noise related because I'm not a trade person. So the first one is, why are we so afraid of pressuring China? This is something that bugs me in all the noise kind of conversations. So I think about what the banking sort of person's response typically is. Well, what if China stops buying our U.S. government bonds? Wouldn't that be really terrible? And I'm not so sure it would be really terrible. I mean, it would weaken the dollar, which would then mean we could start exporting more. So, and I'm not the only one to say this. I mean, some people say, pressure them. It wouldn't be a bad thing if this system kind of fell apart, but we do seem to be timid in this, and obviously they're probably complicated reasons. And maybe it's just that we've gotten really used to cheap stuff that we buy at Target and Walmart and all that sort of thing. Addicted to that cheap stuff, so we don't want to see those prices of those China imports rise. The other thing is, I'm curious about other countries with large foreign currency reserves. So if we were to take the position that you suggest on China, does it mean that there are other countries that would be susceptible to a similar legal analysis? I mean, I'm not saying this is anything new. This is a legal action that is available, and the bill that you're talking about would make it easier. But your argument is that the law is already there. Do we suspect other countries with large foreign currency reserves? And obviously, that's not the only way China manipulates their currency, but there are other countries with large foreign currency reserves like Japan. Do we suspect them of doing the same thing, and would we, is there a lot of incentive to use the same kind of legal analysis in attacking some of their practices?
Well, on the subject of other countries first, Japan has been a target on Capitol Hill. Japan, up until I think 2003, intervened on the scale that China did, and it was more of a direct intervention. And the auto companies, particularly, it's sort of, there was an interesting dynamic. The big auto companies, the big three, I guess now big two, but the big three back then used to really complain about Japan, but they didn't want to complain about China because the components are coming from China, which makes their cars cheaper. But Japan has amassed a very large stash of foreign exchange reserves, but they stopped intervening, like I said, in 2004. And what they do instead, the term is, I think, usually uses jawboning, where the official government will sort of have an unofficial price. It used to be for a long time 90 yen to the dollar, and that held. I mean, there was sort of the implication that if the yen veered too much from the government's target rate, then they would resume. And for a period, they did resume intervening, but they subsequently stopped. the countries that are most, likely, at the top of the list that would fall into this, well, I guess that have manipulation problems in general would be generally Taiwan, South Korea, but whether they would fall under the subsidies code is a different question, because whether you use traditional manipulation, that arguably is outside the purview of a subsidy. That it's a direct, just government buying dollars in the market. It could, but it's not as obvious. And then on the other question of, and this was one of the more the question on what happens if they sell our debt. That's something that Senator Clinton used in the campaign, over time, when I was involved in this, that argument was very much put forward by people that were not interested in this issue. That, well, if they get angry at us, if we let me do these, they'll just unload everything that they have. They'll send the dollar tanking. Our inflation rates will go up. Our economy will ground to a halt. That question was confronted by Alan Greenspan when he would testify before Congress regularly. And from my recollection, is the argument that he would make is that of the outstanding obligations of U.S. debt, China, while they hold a lot, it's only something like 5 to 8%, and that, while there would be probably a short-term problem, that it wouldn't be that severe, and that other sources of capital or other sources of savers would come in and buy up that debt.
And I think we saw in the financial crisis that that's where all the money goes. So I don't think that we'd have a problem replacing, as you say, other borrowers are quite willing to park their currency with the United States. So.
Yes. Would it be inappropriate to ask permission? Just be practical.
Well, there are some banks that are there are some banks that are selling yuan in the United States. I think you could.
There's 3 or 4 of them.
Yeah, so that may be one, but this is being recorded, and I don't want anyone to think that I'm, or a negligence claim or something like that. Anything else? Professor Malloy.
Thank you for your presentation. I did want in my international regulations, but I did not know writing the paper until it showed up in class and gave me a copy. I was honored that you won this. I knew that we were back at a lobby. I'm on the China Committee International issue since 2002. We issued out a report that this was going on. The question is, the law that Congress passed in 1988, requiring creditors to identify countries that underprice their currency. I don't know, counsel is not banking when that law was written, virtually based. And after that law was passed, the first Bush administration identified Taiwan, Korea, and then the Clinton administration in 1993 identified China as trying to manipulate. At that time, they have not named anybody. They're saying the law is unclear. Do you have any opinion of why was the law clear in 1991, 1993, and it became unclear afterwards?
Well, again, you were there. You were in the Senate Banking Committee, and I suspect you know the answer, but I think I do too. And I remember the law was drafted with certain countries in mind. And there was a problem with Japan in the 80s that was solved with the Plaza Accord, sort of an international agreement for other countries to revalue their exchange rates. There were still problems, and China was cited. There were, like you said, under the 88 Act, every 6 months, Treasury must do a report and analyze the exchange rate policies of our partners, and then to cite those that fall within the statutory definition of manipulating their currency. And it did happen in the first George Herbert Walker Bush administration, and it did happen up until 1993 and 94, where Lloyd Bentsen was the Treasury Secretary. And then in 1994, when Bob Rubin became Treasury Secretary, and then Lawrence Summers, and then Paul O'Neill with the George W. Bush administration, John Snow, and Hank Paulson. And then now again, we started with Timothy Geithner. They've all refused to cite China as a manipulator. And it goes back, in the start of my presentation, I talked about Marcy Kaptur and how she sort of defines politics on, and categorizes politicians on who's willing to confront global capital. And Bob Rubin was a former chairman of Goldman Sachs. Larry Summers, in that same stead. Tim Geithner had a banking background. Hank Paulson was also a former Goldman Sachs official. And when we were involved, in the banking committee, and you were sort of our guiding angel, I would say. I mean, you were very, very helpful, and you made the banking committee took us more seriously because of you. The Wall Street was against this, and Stephen Roach of Morgan Stanley was one of the more active ones, and you can draw, you can only infer why. I mean, we couldn't even really engage them because they were, so powerful and so invisible at the same time. But I think that's really the dynamic is, China entered the WTO in 1999. Trade has expanded dramatically, and we live in a different world than we did with George H. Walker Bush and the first few years of the Clinton term, and then subsequently where international capital became king, and exerting control over it became subordinated to productivity and global growth. And I just want to, you mentioned the China Commission, which was created in 2000 during the China's WTO accession. The China Commission has been, unbelievably helpful to, Washington and people understanding, how it works. And I didn't directly mention the China Commission in the paper, but the China Commission has been extraordinarily effective. And I think that, when people saw the commission being created in 2000, they didn't realize how long it would be around and how effective and really a persuasive voice on all of the implications of China trade. So, I learned a lot from you, and I appreciate it.
Well, thanks for everybody was really impressive in many series this year. An ambitious topic and ambitious policy presented. Thank Professor Spooner for participating. Miles for keeping it all off. Everyone, especially Professor Marston and Ted for today. Please, Ted, accept. We know what you really wanted him to name. Join us in the atrium now for a reception in Ted's honor. Please come back March the 17th for the second series. We're We'll talk on anti-spike seizures of lawful engineering medicines. So we look forward to that in a second. See the scholar series this year. So again, thank you for coming.